The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. You may be seated. This morning we have 4 cases before the court. 3 of them will have oral arguments, and the 4th one will be submitted without oral argument. The first case is Andrew versus Hamilton County Public Hospital. Second case is Liquor Bike versus Iowa District Court for Polk County. Third case is Tracy Barkalow versus Brian Clark and others. And the final case is State of Iowa versus Travis Jordan. We'll start with the Andrew versus Hamilton County case. Mr. Bauer, would you like to give a sound check? Justice Apple is participating remotely today.
Testing 1, 2.
Thank you, Counsel.
And Mr. Thomas, would you like to give a sound check as well?
Testing. Hello.
You're going to need to speak up a little bit. Try it again, please.
Testing, testing.
I can hear you. Thank you, Counsel.
When it's your time to argue, you might want to just get a little closer to the microphone. Okay, thank you. Mr. Bauer, when you are ready, you may commence.
Thank you, Your Honor, and may it please the court, counsel. My name is David Bauer. I'm with the law firm of Nyemaster Good, PC, and I represent the appellant in this case, Hamilton County Public Hospital, along with my colleague Fran Haas, who is not in attendance here with me today. This case is an interlocutory appeal that presents 2 issues for the court. The primary issue relates to the plaintiff, in this case, Dr. Andrews' defamation claims and the district court's denial of the hospital's motion for summary judgment. Specifically, it relates to the proper application of the statutory immunity that exists for citizens when they file a confidential report with the Iowa Board of Medicine. The hospital submits this is a matter of significant public importance. Dr. Andrews' defamation claims here arise solely out of written documents and primarily 2 reports he filed with, the hospital filed with the Iowa Board of Medicine. Just very briefly, by way of background, this entire situation arose when the hospital received contact from multiple pharmacies raising significant concerns with prescriptions that Dr. Andrew had written. The pharmacies had reported they had attempted to contact Dr. Andrew with no response. The hospital investigated that matter and discovered what it deemed to be significant concerns with the prescriptions for 2 patients and a surgical intervention with respect to one of those patients. Based on what was discovered, the hospital's then CEO, Lori Rathbun, terminated Dr. Andrews' employment and his agreement with the hospital effective immediately. Following termination, Dr. Scott Altman, a consultant for the hospital, filed these 2 reports with the Iowa Board. There he provided a detailed factual summary of the relevant facts and also included for the board copies of reports prepared by the hospital's chief nursing officer, Lisa Ridge, and chief medical director, Dr. Nicole Ean. I think it's important for the court to understand first, Dr. Andrew does not dispute any portion of the facts that were recited in these reports. The form complaint, which is in the record as filled out for the court, asks the question, what would you like the Iowa Board of Medicine to do about your complaint? And in response, Dr. Altman raised his concerns about Dr. Andrews' prescribing practices and his decision to proceed with a second surgical intervention for one of the patients. As far as the hospital can understand, Dr. Andrew takes issues with those concerns, and his defamation claims arise primarily out of these 2 written reports. The primary issue here for the court is whether these reports are actionable as defamation or whether the included statements are protected statements of opinion. The parties agree here. The court uses a multi-factor analysis in answering this question, sometimes referred to as the Janklow factors, referencing an 8th Circuit case from where they were derived. Very briefly, those 3 factors, the first includes, does the
Counsel,
statement...
can you clarify your position for me a little bit? At least it wasn't clear to me in the brief. Is the primary argument here that these are opinion and or that the statutory immunity applies even if it's not opinion?
Justice McDonald, it's both. Primarily, again, as far as the hospital can tell, the only disputed statements are the several we've referenced. Those are clearly opinions. To your point, Justice McDonald, Dr. Andrew concedes that regardless, under the statute, he's got to prove actual malice, which requires both falsity and knowledge of that falsity. And so here, the argument would be twofold. Number one, we believe these statements are opinions, and it's important in this context for hospitals and clinicians for the court to recognize that. But secondarily,
Counsel?
Yes.
Related to that point then, what about at least the suggestion that Dr. Andrew might have been colluding with his client to commit illegal activity? Is that an opinion, or does that call into question whether or not someone is committing a crime?
It's a good question, Your Honor, and I think we first have to look at what was actually said. I think Dr. Andrew characterized Dr. Altman's statement as accusing him of being a drug dealer. Clearly, that's not what was said. What Dr. Altman said after a lengthy recitation of undisputed fact is he, as a clinician, this raises questions in his mind about three things. Was Dr. Andrew simply naive? Was he incompetent, or was there something else going on here? The obvious conclusion would be, was there collusion or some type of drug diversion, which does happen. To your point, the third Jankel factor, or third and fourth, depending on the decision you look at, really come into play here, because it's important to look at both the literary context and the social context in which these reports were filed. And the various factors we've outlined in our brief, I'll just discuss a couple of those which I think are dispositive on Your Honor's question. First, we look at the audience and the intended audience that the statements here were made. Clearly, the only audience was the Iowa Board of Medicine, which is the statutorily designated audience for these types of claims. Any complaints that are filed with the board are confidential under Iowa law and can't be disclosed for any reason, whether in other litigation or pursuant to a subpoena. We can presume, I think, that the board, because it's set forth in the statute, knows that the complaints it receives will be based to some extent on the complainant's opinion about what it was that went wrong. I think we also have to look, too, as the case is
Mr. Bauer,
Yes.
what's the interrelationship between the federal statute and state statute in terms of preemption? So under the federal standard, as I understand it, the privilege isn't pierced or not lost unless there's actual knowledge of falsity, which would be different than the state statute for immunity. How do those two interrelate with respect to this tort claim?
Well, you're correct. The standards are different. And as I read the immunity in the Healthcare Qualified Immunity Act, it is broader in the way Your Honor described. I think here it's helpful to separate the reports filed with the Iowa Board of Medicine and then the subsequent document filed with the National Practitioner Data Bank. Arguably, as Dr. Andrew has highlighted, or I should say the district court really raised the issue of the report to the federal body. There, even if that statutory immunity did not apply, Justice McDonald, Dr. Andrew has conceded that the same actual malice standard would apply in analyzing that report under Iowa law because of qualified privilege.
Counsel, actual malice or state of mind issues generally are poor candidates for summary judgment. Was there a fact question here based on some inference that the hospital administrator wanted to get rid of the plaintiff because he was overcompensated?
Sure. And it's a good question, Justice Waterman. I think the district court, to some extent, had two issues bleed over into each other. There is a breach of contract claim here. And the CEO, Ms. Rathbun, who's deceased, when she testified, said, no, I terminated him primarily because of these issues. But there were performance issues in the background. That is still a part of the breach of contract claim, which will be tried at the district court regardless of this decision.
Mr. Bauer, I'm sure as a trial lawyer you tell your clients, be sure you just answer the question. So the question that was asked by the Board of Medicine is, what would you like the Board of Medicine to do about your complaint? And then what the consultant responded, Dr. Altman responded with, was several paragraphs worth of stuff, some of which is not really an answer to the question. Does that affect the scope of the privilege, the fact that he kind of went beyond answering the question?
Your Honor, I don't think it does. In looking at the primary report with patient number 1, the conclusion, I think, or the suggestion of Dr. Altman was, does this physician's prescribing practices need to be reviewed by the court, or excuse me, by the board? And I think what Dr. Altman is doing here, and I think it's clear, is simply taking the facts and explaining to the board, this is why I have concerns. What is it you want the board to do about it? That's what's asked. Can the board review his prescribing privileges? Does that need to be reviewed? And if you look at the final point I think he made in both of these reports, is do we have other patients that may have had a problem here? As the hospital did its investigation, they identified at least one other patient where there were issues. And so to your question, no, I don't think it takes it outside the scope of the opinion. I think this is simply a physician summarizing his, in this case, view of the undisputed facts, identifying, here's why I filed this. What do you want us to do? We want you to take a look at his prescribing practices and potentially the surgical intervention that was at issue.
Mr. Bauer, if we allow this defamation claim to go forward, will there be a chilling effect on reporting to the Iowa Board of Medicine?
Your Honor, I think there certainly may very well be. The reason for the immunity and the protections that are provided here is because the legislature determined we want complaints, whether they're meritorious or not, to be filed confidentially so that the board is able to address those issues as a matter of public health. And oftentimes in these cases, you get to summary judgment, or maybe very early in the case, where the hospital or the complaining party to the board can come in and say, no. Here are the facts that I looked at. I've been a doctor for how many years? This was my view. I was really concerned. And although Dr. Altman is not a licensed physician in Iowa, as we pointed out in our papers, licensed providers in Iowa have an obligation to raise concerns, not because they're certain of it, but because they believe a fellow provider may have engaged in certain conduct.
Counsel, I apologize for interrupting, but I wanted to ask you about specifically the report that was made to the national database. Was Dr. Andrew provided a peer review, and did he need to have been provided a peer review for that report to have been made?
Your Honor, he was not provided a peer review. That's the short answer to your first question. The issue of whether he was required to or not was not an issue that was briefed or discussed with the district court. It came sua sponte in the court's opinion. There are statutory issues I think we'd have to delve into further. But again, the larger point, I think, Your Honor, on the report to the federal.
Well, and so to that point, does the statutory immunity apply to the reporting itself, or did there had without where there was not actually a peer review? That's, I guess, the question.
I understand. I think as a matter of law, if the procedures were not complied with, the statutory immunity would not apply. But in this case, again, and I think Dr. Andrew has conceded, even if that were the case, the defamation claim would proceed under Iowa common law. And the same qualified privilege that's recognized under common law requires the showing of actual malice. And here, again, we're still unaware of what portion of that report Dr. Andrew claims is untrue. It literally is a recitation of the facts. It doesn't include any of the opinions, if you will, or concerns that Dr. Altman expressed.
Would the report itself then be a false statement?
Depending on the circumstances, Your Honor, as far as whether the report was permissible to be filed or not, one could argue that perhaps the act of filing could fall under that category. But again, it's not an issue that the parties addressed. And I think, again, the point still comes back, and the evidence in the record through the testimony of Ms. Ridge, who was the author of the document. She said, look, I wrote it. I believed we had an obligation to report the fact that we terminated employment and terminated clinical privileges. I ran it by our medical director, Dr. Ean. She had no substantive concerns, and we filed it. So I think you're correct. There would be an issue here potentially of whether the statutory immunity applies, but I think we end up in the same place.
Counsel, can I talk a question about the meaning of malice within the Iowa immunity statute? So at the time that that statute was passed in 1993, our case law on malice still was using the old kind of actual malice, ill will standard. And it wasn't until 10 years later that we clarified or maybe adopted a different rule, adopting the New York Times versus Sullivan malice standard. So as we read that statute, how do we interpret the word malice in that statute?
It's an excellent question, Justice McDonald. I don't remember the precise year when that standard was changed. I agree it was sometime after 1993. And so I think that the court's task at that point is to use the interpretation of malice that was in the case law, even if not directly discussing that statute, to inform its interpretation of what that means here.
Do you mean our current case law or the case law as it existed in 1993
Our
when the
current
statute?
case law, as the term is defined today, I think is the better approach. I see my time is up. May I just briefly conclude?
So you may wrap up.
I just want to add, the second claim for the court relates to Dr. Andrews' claim under Chapter 91A. We would just submit that that claim is controlled by this court's ruling, I believe in 1986, in the McClure versus International Livestock. There's a claim for breach of a notice of termination provision. That claim exists in the district court. There may be a remedy there. And under McClure, there is no claim under Chapter 91A, given the facts of this case. Thank you, Your Honors.
Thank you. Mr. Thomas, when you're ready. Is your microphone on?
It is now.
Okay, thank you. And Justice Apple, if you can't hear him, please get our attention.
I will.
May it please the court, my name is Mark Thomas, and I'm here on behalf of Dr. Andrew in this case. We have a considerable disagreement about the way this case should be disposed of. We're here on an interlocutory appeal, and of course the standard is that the evidence before the court should be viewed in the light most favorable to Dr. Andrew. He was employed as a general surgeon at the Van Diest Medical Center from August of 2008 to December of 2016. That's 8 years, and the record in this case shows that he's being criticized, well, he's personally criticized and informed after the fact about one person, and then another patient was kind of also mentioned, not to him in a meeting. So doing the math, we have a surgeon who's been on the job for 8 years at this particular hospital who has now had two people care of two patients complained about. The record shows that for most of the time that he was on at the hospital, he was on the executive board, and he, in the record, would show that he was one of the folks who pushed and established peer review as part of their process. Of importance to our facts is the fact that when his life changed remarkably when Lisa Rathburn became the CEO of the hospital, because almost immediately she started making changes, and she saw him, and she testified, and we have undisputed at this stage evidence that suggests that she saw him as an overpaid, way overpaid person, and she determined that she was going to fix that, and she did in a series of maneuvers, managed to reduce his salary, cut his call time. She was busy shoving him off into another hospital at the time when a complaint came in, and she reacted.
Mr. Thomas?
Yes, sir.
Over here, sorry.
Sorry.
What in particular are the statements that you allege are defamatory?
The statement, well, there are two groups. The first and most important is the report made to the Iowa Board of Medicine, and I'll read it because It says this, and this is Dr. Altman. He's an Illinois emergency room doctor who was acting as the enforcer for Ms. Rathburn's efforts to trim out the dead wood as she saw it. He says this, the volume of narcotic prescribing appears to be well beyond acceptable under any circumstances. It raises questions of market naivete, gross incompetence, and/or collusion with the patient for self-use, dealing, or distribution.
Opinion at best?
No,
It's not, where's the false factual statement there?
well, let me put the context for Your Honor. Dr. Altman testified in his deposition that he was telling Ms. Rathburn, slow down. None of us are surgeons. We haven't had any surgeons review the case. Well, it has not been established that any standard of care has been violated. So
Well, but counsel appears and then raises questions. I mean, this is kind of soft language. This isn't the language of a statement of fact, is it?
I believe it really is. The question is, are we talking about opinion or a statement of fact? Well, the simple math is an opinion or a statement of fact is one that can be disproved or proved. Well, he's been, in our view, accused of being a drug dealer and or of colluding with his patient for using drugs himself. Those are facts that they're not opinions. There's a question mark at the end of a statement of accusation. So if you're accused of being a drug dealer, you can disprove that. If you're accused of using drugs with your patient, you can disprove that. They are statements of fact, and they are career-ending statements of fact because...
Well, wait, hold on.
Yes, sir.
I'm sorry to interrupt you, but he's not saying he's a drug dealer, I don't think. I mean, I'm parsing the language, but that's what we do, of course. It raises questions. So the Board of Medical Examiners is the state entity that investigates these things. But he's not saying as a matter of fact that he's this, that, or the other thing. He's saying, well, he has the previous facts, and then he says, based on those facts, it appears, and that it raises questions. I'm maybe the distinction between facts and opinions isn't necessarily crisp, but it seems to me you're sliding down the spectrum toward opinion when you have words like appears and raises questions.
Well, I respectfully disagree, Your Honor, because what we have is the person who's making this report has testified that at the time that he was making this report, he wasn't certain it was in any way true. So if you dump a question like this in front of the Board of Medicine and you say, I believe the facts that I've just recited.
Well, counsel, sorry, over here again. Don't we have to look at the full context, though, of where those statements come from? And, you know, as I look at the report, it says your expectations, and then there is a question that has to be answered. What would you like the Iowa Board of Medicine to do about your complaint? And the statements that you're talking about come in response to that question. Don't we have to look at that question too and kind of look at the full context?
I agree, and the context that we're concerned about, and of course, we're the non-moving party. The context is the person who's posing these queries, which are in our view clearly defamatory, is doing so at a time that he is aware that he doesn't have any of the evidence to support his concerns.
What does the record reflect on how many pills Dr. Andrew prescribed to this patient over a 2-year period?
I don't remember the number, but it's...
That's a question I wanted to run to. It looks like the district court took judicial notice or incorporated the federal ruling. And in those findings of fact, it says the amount of hydrocodone prescribed TC over a 4-year period, approximately 11,940 doses, was of significant concern. My question is, how do you pussyfoot around that? How do you think they should have responded when they're faced with allegations, just kind of like, I don't know, Board of Medicine, just need to look into it and figure it out. Are they not supposed to tip their hand at all as to what they think?
Well, I think that, first of all, we now know after the fact that the Board of Medicine declined to do anything about this, and we also know that the experts that testified in the case didn't find any daily overprescription of anything. So we have
Result, but getting there when just concerns like that 11,940, that catches your eyes. What were they to do?
Well, with all due respect, Your Honor, what they were not to do was to immediately assume that he was a drug dealer or a drug user without any.
I'll ask you this, related to that. My recollection is the number was somewhere between 12 and 15,000 pills this doctor prescribed to 2 patients over a 2 to 4 year period. Doesn't that at least raise questions, going back to Justice Appel's question to you earlier? Whether or not it's true, it seems like that would raise questions for a physician, and he raised them. He didn't accuse him of it, but he just said this warrants further investigation. That was his full statement.
And I accept it. My response would be this. My client said, let's have a peer review. Let my peers review my conduct and see if what I did is inappropriate. That didn't happen. We have Dr. Altman, who's an Illinois emergency room doctor.
And so, counsel, is there a requirement before a report is made to the Board of Medicine that there be a peer review first?
Not to the Iowa Board of Medicine. There is with regard to the National Practitioners Database. But no, there's not a requirement that happen.
Well, counsel, if I might follow up on that point, were the statements that you are alleging are defamatory here, was that part of the federal report?
The language is not identical in the federal report. So what I read is not in the federal report. I've got it, but it's different language and doesn't accuse him of being a drug dealer or being a drug addict. Our problem is not that we don't take issue with the fact that everybody has a right to investigate or be concerned if they are faced with facts that they think, well, this is a problem. But what happened, and I think the evidence is pretty clear in this case, is that they went from seeing what this number was to immediately accusing him of being a drug addict and a drug dealer. Well,
Counsel, was it,
Different terms, that naive or something else, or?
being naive is not actionable. I mean, if I say someone's naive, we're not claiming that part was actionable. But when you can't just put a question mark at the end of an accusation and somehow make it okay.
But counsel, isn't it true that these concerns over here, were originally raised by the pharmacy? It's not like it was an internal concern. So these were raised by pharmacies to the hospital, and an investigation of some type was done that led to this report. It's not like they just out of the blue decided that they were going to report Dr. Andrews. How does that play into the analysis?
I don't believe there was, well, my memory of the facts is somewhat different. I don't believe there was ever an investigation of, what they did was send it to the Board of Medicine to do an investigation. The investigation that they conducted was sort of an after-the-fact situation, but if you'll recall, what happened was that that Lori Rathman, the CEO, said, I don't have to do any investigations. I don't have to send it to peer review. I'm going to make an administrative decision. You're out of here. So, but our point when we say she's not a doctor is that what happens, she says, I'm the CEO. I make an administrative call. That says, he doesn't have any right to have any of this heard by anybody who knows anything about medicine. Your Honors, I'm not quarreling with the idea that there shouldn't have been an alarm bell sounded, but we have a procedure by which we figure out if the alarm bell is really saying something bad is happening or whether there's a medical explanation.
But is that different than a defamation claim? I mean, you have other claims in this case, and I think that's where I'm struggling with is having conceded now that there were issues that raised alarms, at least, what makes this defamatory?
Well, because what they did, first of all, they did so without ever having someone with a similar background do a peer review. But what they did was they said to the Board of Medicine, they didn't say, check and see whether prescribing all these pills is appropriate. That's what they now say is that's what we were worried about. Too many pills going to these two patients. Instead, they said, we think he's a drug dealer, we think he's a drug addict. That's what the message received by the Board of Medicine was. And the effect of that is and I cite the case of Belcher versus Little, the effect is my client's career is over instantly because the fact that the Board of Medicine ultimately decided this isn't something that they're worried about didn't matter because when he goes to try to find a new job, he says, he gets the question, have you ever been fired for cause? Yeah, what was that about? Well, they said that, I was a drug dealer and I was overprescribing medication. Did you ever have a complaint filed with the Board of Medicine? Yes, but the complaint was filed, but the Board of Medicine found that there was no problems. Well, what did the complaint say?
Isn't there a difference between somebody saying he was a drug dealer and we're concerned about the number of pills prescribed, and that could mean there's drug dealing going on? Isn't there a difference of opinion? And you're saying as if it's a fact, and I'm not hearing it in that statement that it's stated as a fact.
Well, I don't think there should be some protection for launching into the worst case scenario without any evidence. Keep in mind the person who said this has already testified in his deposition. He wanted to slow down and do the peer review first. But so to answer your question is, our position is you can't just protect yourself from saying terrible things about people by saying, maybe hypothetically, or I'm just raising this point.
I'm struggling to understand how this standard you're articulating would operate in the real world. So imagine outside of the hospital context, you have internal investigations at companies all over the place. Let's say there's money missing from a cash register drawer, bank accounts, whatever, and HR receives a complaint and somebody says, well, this could potentially be theft, we need to investigate. Or potentially something's going wrong in the company, maybe it's not theft, we need to investigate. Are you saying that's defamatory because somebody's raising a question about potential misconduct and they decide as an organization they need to investigate?
No, but I think you've changed.
Different than this case.
It's different in the fact that you have an investigation in your scenario, and we don't in ours. We wanted an investigation. We wanted the peer review. They didn't do that. They said it's administrative. Instead,
Can I respond to the question, Chief? As you describe what happened to your client, it occurs to me all of the same things would have happened if Dr. Altman had written the report more carefully, as you say he should have done. Am I correct or not? I mean, the hospital still would have fired him, and there still would have been an investigation by the Board of Medicine. So, and your client would be suffering the same consequences you're complaining about.
I don't believe I respectfully disagree because it's one thing to say we have concerns about the amount of medication that you're prescribing to these patients. And let's just say that's the complaint that was made to the Board of Medicine. We think he overprescribed pain medications to patient X. That's a completely different thing than saying, and we think that he was using drugs.
Well,
and we
well,
think
what practical impact would it have had on your client different from what actually occurred?
Well, I think it's the difference between saying I had a DUI or I'm a raging alcoholic. I mean, it is a problem for my client because he can explain by showing the Board of Medicine declined to do anything about his overprescribing because they found that the prescriptions were warranted under the circumstances. But you can't recover from a claim that you're a drug addict and that your last employer thought you were colluding with your patients to sell drugs. Those aren't opinions. Those are provable facts. And my client should be allowed to at least say, where's the evidence that supports this idea that somehow I'm selling drugs with my patient? That's not a leap that a normal person makes without some sort of malicious intent, especially with the evidence that that person knows that We haven't had a peer review. We haven't had other surgeons look at this. There may be medical explanations.
You may wrap up.
I'm sorry. I'm
That's okay. You
really
can
out-
wrap up.
I will simply say that with regard to this case, we think that the hospitals killed a gnat with a sledgehammer, and in so doing, took my client's career completely away and forever, and it didn't have to be so. Thank you.
Mr. Bauer?
Thank you, Your Honor. I want to make just a few comments. One, I think that we're confusing issues on a couple of topics. Dr. Altman, part of his consultancy with the hospital was to work with the hospital administration on staffing issues, which included things like peer review. And Mr. Thomas's comments about Dr. Altman encouraging the CEO to slow down related to the termination decision. It didn't have anything to do with these reports, which is what we're actually talking about. Mr. Thomas said the record suggested Dr. Altman didn't believe that the statements in these reports were in any way true. That's completely unsupported by the record. Several of your honors addressed the language of the Iowa Board reports in particular. Things like the volume appears to be excessive.
Well, let me push back on that just a little bit. I mean, and you know, we were dealing with the dichotomy of a question versus a fact, but don't some questions imply fact? And let me give you an example. If I said, you know, there's some question about whether person X has a sexually transmitted disease. Don't know for sure. Needs to be investigated. These are just questions. Now, I've posed them as questions, but one might think, ooh, that has a sting, doesn't it? And so I wonder if our kind of rigid approach between questions are okay and statement of facts are okay, are different. I wonder if that's right. I mean, what I hear counsel saying is, okay, it was kind of, you know, the verbiage was one of a question, but to an objective observer, they were really statements of fact. You get the gist of what I'm saying, I think.
I do, Justice Apple, and I don't think, I agree with you. There are certainly going to be situations where a question potentially could be actionable. But here I think it's critical to look at the context, the final factor that's set forth in Janklow. It would be one thing if Dr. Altman had made a quote like this in a newspaper. That's not what happened. He provided the information and ultimately his opinions to the board in the context of confidential proceedings.
So, counsel, looking at the context, this is a situation where your client says that we have a right, we have a duty to report these sorts of issues to the board. But isn't it for the jury to determine whether that's been abused in this case? I mean, isn't that what the district court held, that this is really a jury call?
As far as whether the privilege, if you will, has been abused?
Has been abused in this case.
I think with respect to the Iowa board reports, I don't think that analysis applies because I think that under the actual malice standard, we've got to first find something that's false and then show that there was malice. And so if we got to those factual questions, Justice McDermott, the question would be, where is the evidence of malice here? I think Justice Christensen highlighted some of these facts are eye-popping, particularly if you're the CEO of a rural or a community hospital and your hospital's getting calls from local pharmacies about these things. And you come to learn about the volume of prescriptions that have been going on, the failure to even acknowledge or recognize the procedural safeguards in place, and also the surgical issue that obviously caused great concern to all members relevant here at the hospital. But back to your larger point, I mean, you're right, at some point, The question of actual malice could be something that would go to a jury. We don't think you need to get to that point, but if you do here, the question would be, where's the evidence? It'd be one thing if Dr. Altman had misrepresented facts.
Well, but you never have direct evidence of malice. Maybe never is a strong statement. Once in a while, you might have evidence of malice that's kind of direct, but usually that's not the case. And that's why, as Justice Waterman was saying, and Justice McDermott is working on a little bit. I mean, ordinarily, before we say that there's no basis for claiming malice, the standard is very high, and it's generally thought to be a matter for a jury. Help me out here.
Well, your point's well taken, Justice Apple. You're correct. Rarely can you point to a single thing and have your aha moment. But there has to be something here. And
Well, how about he's paid too much? And in professional life, some people measure success by the number of dollars they get, and this guy's getting a lot of money, and that can generate ill will and arguably adverse employment decisions.
I see my time is concluded.
You may wrap up and answer his question. Thank you.
Sure. And I will, again, Justice Apple, just to respond briefly, I think we have to look at the evidence that is here, and malice requires knowledge that something is false or a reckless disregard for its truth. There's no evidence whatsoever to suggest that Dr. Altman knew that his concern that the prescriptions and conduct at issue raised questions about drug diversion was false. And there's also no evidence whatsoever to suggest that he was reckless in making that statement. Again, as several of the justices have pointed out, the facts here do permit a reasonable physician to conclude this was either a mistake, naivete, misconduct, or something else. And all Dr. Altman was doing here is presenting to the board, look into what this might be. So to conclude, Your Honors, I would simply state that the hospital asks this court to reverse the district court and find as a matter of law that Dr. Andrews' defamation claims and his claim under Chapter 91A fail as a matter of law, and remand the case to the district court for further proceedings on the remaining breach of contract claim. Thank you.
Thank you. The case of Andrew versus Hamilton County Public Health is hereby submitted. We will allow a transition of attorneys with a brief period of time in between to clean, and then we'll have the next case of Liquor Bike versus Iowa District Court for Polk County.